Okay, good morning, everyone. Welcome to summer session 3. This is the final of our summer sessions, and we're really excited to talk about judicial review, incorporation, checks and balances today. Some of the best topics. And in addition to going over some of those great topics, you are going to get the opportunity to draft your first testimony and present it during this summer session. So, really exciting. And we're going to go ahead and get started by having everyone introduce themselves. Hi, hopefully you know me by now. I'm Sabrina McGraw. I'm president of CASE. I'm an alum of the program from 2013, have been volunteering ever since, and I am a lawyer working for the California Department of Justice as a deputy attorney general. Nathan, why don't you go introduce yourself?
Yeah, sure. Hi everybody. If you were at the first summer session, you may or may not remember me. I don't know. But my name is Nathan. Also an alum of the program, also on the board of CASE, uh, 2016 Unit 1. Um, and I'm a project manager at the Washington Metro. So if you're ever on a train in DC, that's half of my work. But yeah, excited to be here and help you guys out once again. And I'll throw it to Joshua.
Hi everyone. If you were here at the last summer session, you might remember me. If not, I am a Unit 1 alum from last year's Foothill team, and it's my second case session, and I will be attending Harvey Mudd this year, planning on double majoring in both physics and political science. So yeah, I'll bounce it off to Patrick.
Hey everyone, my name's Patrick. Hopefully, I met you at one of the prior case sessions, but I'm currently a third year at UC Berkeley studying civil engineering and business. But I also take passing interests in, of course, the Constitution, law, legal rights. And back in the day, I was a Unit 5 at Foothill High School. So nice to meet you all.
Hi everyone.
I will pass it off to Ernest.
Oh shoot. I guess I jumped the gun there. But hi, my name is Ernest Zhang. I'm a member of the 25 team at Foothill High School. I was also Unit 5, so Unit 5 represent. And I go to the University of Maryland. Proud to be here today.
I can go next. Hey everyone, my name's Rashab. I was part of Amador's Unit 4 back in 2020, and I've been volunteering with CASE ever since. Currently, just a family law paralegal for a small firm and tutoring the LSAT, but hopefully trying to go to law school soon. But I think I've probably seen a few of you at the previous summer sessions, and if not, welcome. And I think last person to go is Natalie, unless there's some other volunteer I haven't seen here.
Okay, yeah. I'm Natalie. I'm alum from Foothill Unit 3 in from 2024 and currently going to the University of Washington.
Awesome. Thanks, everyone. So we're going to go ahead and jump right in. I'm going to rearrange the agenda slightly. So we're going to first start off with judicial review. So I'm going to share my screen. So this one's a little bit more interactive than usual. So I encourage you to actually participate either in chat or feel free to unmute yourself to answer the questions. So I'm talking about judicial review. So what are some ways that the Constitution has changed over time? I will not move on until I get answers. Amendments. What kind of amendments? Give me some examples. Allowing an income tax. Great. Any other examples? Bill of Rights. Yep, that's a big one. defining citizenship, expanding suffrage, 14th Amendment. Great. So I'm seeing lots, and there's the 18th Amendment. Very good. I'm seeing lots of amendments. Is there any other ways that the Constitution can change? Oh, judicial review, Neil. Yeah, you got the point here. So can someone tell me why judicial review is a way that the Constitution can change over time? And feel free to unmute yourself and just explain because it might be easier than typing. All right, we got the courts interpret what the Constitution actually means. Okay. Our interpretation of the Constitution can change. This can change over time, and new laws can be overturned. Hold on, chat's popping off. Okay. This can change over time, and new laws can be overturned and allowed. It can affect how the Constitution is interpreted without changing the Constitution itself. Yes, that's great, Layla. Okay, so what is judicial review? I think a lot of your answers are explaining or hinting at it, but judicial review is the idea that the actions of the executive and the legislative branches of government are subject to review and possible invalidation by the judiciary. Now, it's important to remember that this is very specific to the Constitution and the other branches of government. If there was no judicial review, would the courts have any role in our system? So somebody said no, and someone else said they would have a more limited role. What do you think that limited role would be? We got yes, but only in trials. Okay. So actually, if there were no judicial review, the primary thing that the courts would do, aside from sort of mediating disputes among parties, like contract disputes, is they would be interpreting the statutes that are actually made by Congress. So they would say Congress meant to do XYZ, but they wouldn't have the authority to say that Congress overstepped its power or the executive branch overstepped its power pursuant to the Constitution. So it's important to keep in mind that judicial review is the idea of the courts reviewing the actions of the executive and legislative branches against the Constitution. So it's the judiciary basically saying that they can't do something that they've done, rather than just interpreting what those actions are. So let's talk about the origins of judicial review. I have a couple up here. So the first possible origin of judicial review is common law. So common law is primarily derived under English common law, though several other countries do it. And it's the idea that there's no written constitution per se, but instead there are developed body of legal principles through case law over time. So it's judge-made law, essentially. And part of this is the concept of stare decisis, which is Latin for to stand by things decided. It's this idea that courts will over time build a body of law and principles that are then relied on later. And common law is partially why judicial review is in place. It's this idea that courts have the role to review. And, an example of common law more generally is the idea of breach of contract. If you make a promise in a contract and it meets certain requirements, common law, judge-made law says that you need to keep the promise and have to take certain actions in order to facilitate that or face certain kinds of punishments. Now, another source of judicial review people point to is Article 3 of the Constitution. It's the shortest of the first four substantive articles, and it says that judicial power of the United States is vested into one Supreme Court and such inferior courts as Congress decides. And in particular, a quote from there is, in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to the law and fact, with such exceptions and under such regulations as Congress shall make. So a lot of people point to that as the basis for judicial review because it's giving courts the ability to determine and have jurisdiction over cases. Now, it's important to note when you're looking at that provision, the difference between original jurisdiction and appellate jurisdiction. So, original jurisdiction means the Supreme Court gets to hear that case first off. It doesn't go through any levels of, some people might be aware that there are 3 levels of courts in the federal government. There's the district courts, which are all over the country. Then there are appellate courts, which is in California, it's the Ninth Circuit. It handles certain, and there's various circuits, and then it goes up to the Supreme Court. Well, in those specific cases, pursuant to the Constitution, which means that it can't be touched by Congress, the Supreme Court has original jurisdiction. But in all other cases, the Supreme Court only has appellate jurisdiction for both law and fact. That means that Congress controls the appellate jurisdiction of courts and can engage in what something is called jurisdictional stripping, which is the idea that Congress could strip the jurisdiction of the federal courts entirely to hear certain matters and or get rid of appellate courts entirely. Anyone have any idea what would happen if we just got rid of all the appellate courts? Who would hear those cases? SCOTUS? Yep, that's great. So Supreme Court could hear it. It would basically expand original jurisdiction to all the Supreme Court, which would not be very efficient. But the other entities that could potentially hear cases is state courts. There's an entire system of state courts too, and although state courts are handling primarily state law, they can also rule on matters of federal law and federal constitution. They just don't get a final say right now. But yes, in theory, they could decide state court cases. The next origin of judicial review is Federalist 78, which was written by Alexander Hamilton. In that, he says a couple of quotes that people often rely on to point to judicial review. One is that the interpretation of laws is the proper and peculiar province of the courts. The Constitution is in fact and must be regarded by judges as fundamental law. He also says that courts were designed to be an intermediate body between the people and the legislature in order, among other things, to keep the latter within the limits assigned to their authority. And finally, whenever a particular statute contravenes the Constitution, it will be the duty of the judicial tribunals to adhere to the latter and disregard the former. Now, the last one on here is Marbury v. Madison, 1803. And you'll hear a lot of times that Marbury v. Madison established judicial review. But the reason I went through these other 3 components here first is because to show you that judicial review was likely not established in Marbury v. Madison, that concept was kicking around much before that. And a lot of the founders understood judicial review to be part of the power given to the courts. But in Marbury v. Madison, it was the first court to really say so. And of course, I forgot I made slides for all of these, which makes sense. So we'll just go through here. But in Marbury v. Madison, 1803, the context you might have heard from your history class is this was in the aftermath of the election of 1800 between Thomas Jefferson versus Aaron Burr and John Adams. Adams had instructed his Secretary of State, who was John Marshall, to deliver commissions for appointments, but Marbury's commission for Justice of the Peace had not been delivered before Jefferson took office. Jefferson, once he was in office, instructed his new Secretary of State, James Madison, to not deliver it because Marbury was a Federalist and Jefferson and Madison were anti-Federalists at the time. So Marbury was seeking to the court to get a writ of mandamus to have the court instruct that official perform a duty, i.e., deliver his commission. There's a couple of ways that the court could have decided this issue. First, the court could have found Marbury had no right to his commission because he needed to be delivered to be valid. He also could have said that the Judiciary Act of 1789 doesn't authorize mandamus for original jurisdiction. And lastly, Marshall could have recused himself because he was a Federalist and the previous Secretary of State who did not deliver the commission at issue. But instead, Marshall and the Supreme Court did none of that. And instead, they basically set forth in explicit terms, cementing judicial review in history. So the ultimate holding was that the Judiciary Act of 1789 gave the Supreme Court, the authority to issue a writ of mandamus, but that the Judiciary Act of 1789 is unconstitutional, and so the court lacks jurisdiction to hear this case. So the idea is the rule of law. No one is above the law, even if it's against the President of the United States. And the Constitution identifies where the Supreme Court can use original jurisdiction, which is in Article 3, Section 2, Paragraph 2. But this does not allow for Congress to act as it should, add to it, should it be appellate jurisdiction. So it cannot be presumed that any clause in the Constitution is intended to be without effect, and therefore such construction is inadmissible unless the words require it. And this is the famous quote from Marbury Madison. It is emphatically the province and duty of the judicial department to say what the law is. So fundamentally, that is the most important phrase for judicial review. And anytime you are in a testimony or you're giving an answer and you're talking about judicial review, saying this phrase about it is the province and duty of the judicial department to say what the law is, that's the most concise definition of judicial review, especially when you're talking about Marbury v. Madison. And this is also something as a lawyer that gets quoted all the time, just as sort of a basic principle. So, as I mentioned, this case didn't establish judicial review, but it was the first time in American history that the Supreme Court used judicial review to strike down a congressional statute as unconstitutional. SCOTUS had previously used judicial review, actually, to uphold a statute's constitutionality in Hilton v. United States, 1796, but this was the first time a statute was struck down. So, what are some effects of judicial review? I have a couple listed here, but if you all have any other thoughts in the chat, feel free to add it. But some of the judicial review effects I've flagged here are it was used to limit the power of the federal government in the case Barron v. Baltimore. It basically started the Civil War because of the decision in Dred Scott v. Stanford and incorporation of the Bill of Rights into the states, starting in Gitlow v. New York, which Patrick will talk about a little bit later today. It's the reason we have limits on some presidential power in Youngstown Sheet and Tube Company v. Sawyer. It desegregated education in Brown v. Board. It outlawed anti-miscegenation laws in Loving v. Virginia, established a right to privacy in Griswold v. Connecticut, gutted the Voting Rights Act in Shelby County v. Holder, legalized same-sex marriage in Obergefell v. Hodges. Any other instances of judicial review anyone wants to flag in the comments? We got Citizens United. What did Citizens United do? We got criminal rights in Miranda v. Arizona. Very good. Allowed unlimited. So for Citizens United, it allowed unlimited political donations and practice to campaigns. And it overturned a congressional law that would have prevented that. There's expansion of executive power in Slaughter. Great. Any others? Civil rights cases overturned. Civil Rights Act of 1873. Roe v. Wade. Yep. And then, of course, the inverse of Roe v. Wade later. Plessy v. Ferguson and how it interpreted the 14th Amendment. Yep. Okay, great. So I have some question. What are the pros and cons of judicial review? Can somebody give me a pro? We got it checks the executive. It's a check on the legislative branch. Yep, those are great, and we're going to talk about checks and balances soon. Yeah, it's an important way for the judiciary to actually maintain its balance in the checks and balance and actually play a key role in that dynamic. We also, somebody said, limits the powers of the federal government and upholds checks and balances. Yeah, great. Enforces the Constitution as a higher law. Excellent, Layla. Yes, I think that's really important. Is in other countries that primarily use common law but don't necessarily focus on judicial review, it's because they typically don't have a written constitution in the same way that we do, where there's a higher law. Let's see. It can protect individual rights. Yes, especially when you have the executive branch and the legislative branch, which derive their power from the majority of people through voting. To have a branch that is checking that they don't cross a certain line can often have protective effects on individual rights, even if it's not the most popular. It protects minority rights. It allows the Constitution's application to be changed over time without amendment. Excellent callback to the start of this lecture, Navika. Yes, that's right. This allows for interpretation to change over time and functionally has the change without needing to go through the formal amendment process, which can often be very difficult. Let's see, it checks the majority. Yes, great, Joel. And interprets the Constitution in a modern context. It can be. And from an activist perspective, it can correct historical injustice. These are all great answers. One other thing I wanted to mention that I don't think people have brought up is that courts are best suited to interpret the Constitution because they're passive actors. They don't get to actively seek out the cases they handle, the cases come to them. And therefore, they're insulated from politics and can just focus on engaging in reasoned decisions typically, rather than, being privy to the people or the majority. Can I get some reasons we shouldn't have judicial review? Any cons? Yes, that's excellent, Brad. It gives a lot of power to an unelected body of people. Yes, it limits certain principles of democracy. Courts are unelected and unaccountable to the people. Layla said it gives a lot of power to justices with lifetime appointments. And Travis said a small group can overturn something the majority agrees with. That's right. Makes the Constitution less stable, yeah, because you have a body of people potentially changing it. Yeah, that's a great point. Another thing that I came up with is the judiciary might be ill-suited because it kind of lacks expertise and gets information only passively. Unlike Congress or the executive branch that can spin up committees, have hire people to do research and understand what's going on, courts only get to see the information that are brought to them by the parties. And that can often lead to making decisions that aren't as informed as the judiciary or aren't as informed as Congress and the executive. And then we also can lead to politicization of the law as courts fight amongst itself for which interpretation is correct rather than what is the most lawful. Nice. And we also have political bias can impact the decisions the judges make. Yes. Are there any other checks on the executive and the congressional branches that maybe would be sufficient if we didn't have judicial review through the judiciary? Great. Yes, we got vetoes and overturning vetoes. Well, we'll go through some of the other checks as Ernest will handle right after this presentation. Oh, we got some others. We got having elected officials, Senate consent required for cabinet positions, cabinet appointments. Great. Impeachment. Nice. Okay. That was great. So before we conclude and move on to checks and balances, I wanted to go over how we actually do judicial review, how the courts handle judicial review. And I will mention there's often a focus on the Supreme Court, but technically all levels of the courts will engage in judicial review if they have a issue that parties are asking them to review the Constitution on. So a district court will do it, appellate court, one of the circuit courts will do it, or the Supreme Court. But the Supreme Court gets the final say on whether those judicial review applications are correct. So here I've kind of set out and described the 5 major theories of constitutional interpretation. These are the ways that courts often view their philosophy and how they apply things. I will say that oftentimes you won't get a particular judge to fit perfectly into one of these buckets, even if they potentially say that they will, if you actually look at how they apply. But I think this is useful to kind of consider both conceptually as how judges actually apply judicial review, and also what you think might be the best way to interpret and apply judicial review. And it's something I recommend you go back to. I think a lot of people sort of hear this part of the lecture and then forget about it once the year starts. But I think it's really important to understand this because it also helps you answer questions in the question and answer period, especially if you're getting a question about what the Constitution means and how a particular issue should be decided. It's a really great framing for folks to divide amongst your panel, to sort of adopt under the originalism principle, XYZ would happen. So I recommend you kind of revisit this later on once you are starting to build your body of evidence and start practicing questions. But just to go over it, the first theory of constitutional interpretation I have up here is originalism. And Antonin Scalia, Supreme Court Justice, is the main proponent of this, though I think most folks on the Supreme Court right now who are Republican appointees would probably say they subscribe to this, though questionable whether they actually apply it in practice. But the idea is under originalism, the meaning of the constitutional provision is fixed when adopted and can only be changed when amended. And so the idea is you're looking at what the founders understood that constitutional provision to mean at the time that they drafted it, and to not really go beyond that. So a great example of this is the current interpretation under the Second Amendment. Justices primarily are looking to what the founders and also the states and people understood the Second Amendment to mean at the time of the founding, and that is the kind of level of protection that they expected to have in the modern day. So you're not taking into consideration sort of modern ideas primarily. Then we have modified originalism, which is interpretations should identify the core concept of a constitutional provision, but it doesn't necessarily have to be exactly the way it was understood at the founding. So you are going to ask, what was the original understanding at a high level of abstraction? And you can kind of look at this in the concept of the Fourth Amendment. You're looking at not just the idea about your papers and effects in the start of the founding was protecting, but also what the principle was, which is the right to be left alone to some extent. Also the right to kind of expect privacy in conversations and in your material belongings. And so you're looking at a higher level of abstraction and then applying it in the modern context potentially. We also have tradition, which is protect rights only when clearly in the text or supported by a long unbroken tradition. And this is kind of what's being applied now in the context of the abortion policy and this idea about rights that are specifically not spelled out in the Bill of Rights right now. This is sort of how the Supreme Court currently assesses whether a right should be protected. Then we have process-based, which is primary role of courts is to affect the process of government. So substantive issues should be left to the political process. And for process, courts should be non-originalists. But for substantive matters, courts should be originalists. So this is kind of splitting the baby. It's this idea that for the process stuff, you should be looking at the modern day context. You're not limited to what's going on at the time of the founding. But when you're talking about substantive rights, you can be more under the originalism bucket. And lastly, aspirationalism, which is that every constitutional provision should be interpreted in light of modern needs. So the Constitution is an aspirational document that should evolve by interpretation. And this is one that I think is adopted primarily by justices who are appointed by Democratic presidents, though it's not certainly limited in this way. And all of these are kind of at a high level, as I mentioned, but they oftentimes intermingle, or you can identify certain provisions in a Supreme Court opinion that kind of apply to the process and idea for all of them or over all of them. And there's a question here. How do they identify original intensive provisions? Great question. They really want lawyers to become historians. But no, they in the context of originalism, modified originalism, and tradition to some extent, you would look at history, you would look at documents, you'd look at really early cases decided by the Supreme Court, or even what was going on in the state level in the various states or the colonies at the time. And also, you would necessarily look to British rule of law and what the British were doing to have a sense of what the people understood was the meaning. But it's a really challenging thing. And a lot of people criticize originalism because you can kind of cherry pick whatever pieces of history support your theory. And oftentimes it's really not clear what the founders would have thought, particularly on something really modern. Like founders had no concept of what a cell phone was, let alone what the founders might have thought was a reasonable expectation of privacy on what's on your phone. And so a lot of times justices have to sort of consider the history and do the best they can going forward. And that's why modified originalism, I think, is like justices will often say they're doing originalism, but I think modified originalism is more practically what is done when you're talking about true modern issues that you're trying to apply. Then we got and also, yeah, Ben, great question, great answer to that as well. As the Federalist and Anti-Federalist papers can sometimes shed some light on that too, but oftentimes there are no clear answers from the Federalist and Anti-Federalist papers on a lot of these issues. Another question we got is, where would textualism fit into all of this? So I think textualism kind of is something that falls under the tradition bucket primarily. And because it's talking about protecting rights that's clearly in the text. But textualism, I think, also is sort of mixed in with originalism. It's this idea that the best evidence of what the meaning of the constitutional provision is what's in the text at the time. That's why it's fixed. And you can look to other pieces of evidence too, but textualism, I think, is sort of built into originalism. Though I will say justices tend to always look to textualism in the first instance, and go from there. And we got some comments that say, isn't originalism flawed because it requires a judge to analyze history, which is out of their purview as a legal expert? That is certainly a major criticism of originalism, though I will say that oftentimes once the policy or the rule is set by courts that history matters, historians can have access to that information by getting experts to testify in the cases to talk about that. So it's not that they're totally isolated from the history because they can have experts talk about it through history. And that's really what's happening in the Second Amendment space. There's a Supreme Court decision in 2022 that came out called Bruin that talks about the importance of history. And since then, all of the litigation around the Second Amendment and challenges to existing Second Amendment gun regulations is employing these historians to talk about at both the founding and also at the time that the 14th Amendment was passed, what different state laws were governing the regulation of guns. And so it talks a lot about those issues. And that's kind of how the judges get expertise in that area. So this is something all to keep in mind. And this is in the presentation of the materials I sent. Y'all have access to this PowerPoint slide. There's also separately a PDF that has kind of a good quick reference chart and a list of all the pros and cons that we've talked about today and some others as well. What about purposivism? I think purposivism is kind of similar to aspirationalism and sort of process-based too. I will mention that these are not the end-all be-all constitutional interpretations. There are many others and many other ways to sort of swing the different provisions into different categories. This is primarily derived from Erwin Chemerinsky, who is a constitutional scholar and who was my professor in law school at Berkeley Law. And so this is primarily where those categories derive from his lectures. However, there are certainly other categories and ways to interpret. And I encourage you all, especially if you're in Unit 3 and Unit 5, where I think this is going to come up the most, I encourage you to look at other kinds of constitutional interpretation theories, and you're welcome to raise them. This is not the limited and all be all. I will say originalism, I think, is the most important to understand given the current dynamic of the Supreme Court now. But I think understanding all the different kinds is going to be important to helping you answer questions. Are there any other questions about this? And I know it's a lot. This is kind of meant to be a primer to give you a good sense of information at the upfront. So when you start researching these issues, you can have a little bit of background and context going forward. But we have plenty of opportunities to talk more in depth about these issues. Okay, great. And with that, I think we'll move on to checks and balances. Ernest, are you ready?
My camera's not turning on, but yes.
Okay, great. Do you want me to do the slides for you?
Yeah, please do that.
One moment. Can you all see my screen still? Great. Thanks, everyone.
All right,
All right, I'm going to
everyone.
hand it over to Ernest.
Thank you, thank you. In my effort to make this this presentation more palatable, I've introduced a tier list to talk about the checks and balances of the three branches of government. So let's just show the image on the next slide. So everyone should be thanking me right now because we would have had to stare at this for 20 minutes. I'm joking. Um, Essentially, we're going to present, or I'm going to present on a tier list format of the checks and balances. We're going to rank all the different types of actions that the three branches of government can like do on the other two branches. So let's go to the third slide. So summarize in one image, Spider-Man. I love Spider-Man. This is essentially what the U.S. government sort of is because they all kind of like point at each other to check on each other, but they don't like check on themselves. So let's go to the executive branch. By the way, like there's an additional action that you need to do for it to show on the tier list. So just press the arrow key once I'm done explaining. Um, so proposing laws. This is one of the actions that the president or the executive branch can do. This is not like actually passing the law, but you can, you as the executive can send draft proposals to Congress. And you're never going to actually write your name as the president on that proposal. It must always be sort of sponsored by a representative or senator in Congress. And it can also come in the form of public addresses, for example, in the executive's annual State of the Union. So you can introduce your presidential agenda. Um, so there's this thing sort of called the bully's pulpit or the bully pulpit. It's like the president's sort of connection to all the people. This is the bully pulpit for the president's connection to Congress. All right. Next slide, please. So on vetoing laws, the president, whenever a bill is passed whenever Congress in both houses, votes yes on it. Then the president can sign it into law. but the president can also choose not to sign it into law. And he or she has 10 days to make it into law. There's this little thing called the pocket veto, where the president kind of just lets it sit there for 10 days and Congress is not in session. And at the end of that 10 days, then it's like automatically vetoed. And these vetoes are very strong because they require a supermajority in both houses to sort of override this veto. In all of American history, out of all 250 years, only about 2,600 were like bills are vetoed. 1.5 thousand of them were regular and 1,000 were pocket vetoes. And only 112 vetoes have been overridden. So vetoing S tier. All right, next one. Um, the president can call special sessions to make Congress convene. Now, this sort of originates out of like the British monarch's power to make Parliament convene. It's sort of inspired by that. But the last time that this was really used was when I think it was Eisenhower in 1948 who called Congress to convene over something called the Turnip Affair or something. I don't know why it's called Turnip Affair. I just know that that is a fact. Here, if you go to the next slide, it will like show like the article where it's originated. So yeah, extraordinary occasions. Some interesting wording from the people who wrote the Constitution there. And that's and because they aren't called that often, I'm gonna put it straight in F tier. I don't think it's that useful in the modern day. Yeah, next slide. Sorry, there's a bit of an animation mistake here. And I guess special sessions vanish for some reason. Um, Next one. Sorry, executive appointments. So the president can appoint two like types of like federal officers. One is your principal officers. So these are ones that must be confirmed by the Senate. This can be like Supreme Court justices or high members of the cabinet. And then inferior officers would be like federal clerks or administrative lawyers. And only a simple majority is required in the Senate to really um, approve these guys. Um, and really, it's not really 51 votes, but it's rather 50 because usually the vice president will vote with the president or with whatever the president wants. So really only 50% you need in the Senate. All right, next one.
Ernest, I think you got muted.
Oh,
The
sorry.
treaties.
Next slide, please.
Treaties is up.
Oh, on my screen, I don't see anything. That's bad. Okay. Sure, I'll talk about treaties. So the president is the chief, like foreign sort of like, sorry, I'm like tripping over my words. The president is the chief, like person who talks to like other nations. You're not going to, he's like the chief ambassador, right? And so treaties are the law of the land, and the Constitution says so. And whenever the president makes a treaty with another nation, they'll both the US and that nation. Let's just go with France since we have lots of like treaties of Versailles, right? Let's talk about like war resolution treaties. Whenever like you want to end a war, you might have to sign a treaty. So how does that work? The president talks to that other nation, they, organize a treaty, and then that treaty gets sent to Congress for consideration. And now it's not only that Congress holds like a vote, but it goes through a committee first. And then once that committee approves it, then it ratifies. But treaties really aren't used today. Since 1990, only 6 to 7% of of deals with foreign nations were treaties. Why is this so? Because executive agreements, this is just the power of the executive branch, are much more popular and they're much more flexible in terms of how you can organize it, right? Because treaties, you have to go through the Senate, you have to go through Congress. It's very slow. But with executive agreements, they can be organized and set up really fast. So treaties, I put them in B tier. Now on to the checks of the executive branch on the judiciary. So number one, the executive branch can determine who sits on, the Supreme Court and on federal judgeships. So this is lower level federal courts. Um, we were talking about Marbury v. Madison earlier. The entire reason why that case happened was because the president wanted to appoint a bunch of judges before their term ended. Obviously, there's some inaccuracy with how it results in judicial review, but um, there you go. I put this as S tier because the executive branch really has an undue influence on all of the judges on the federal, like sort of on the federal courts, and this gives them lots of power. One balance that would ha arise of this would be they all have to be confirmed, and also the previous president, whoever it may be, appointed judges too, and those judges sit there for life. So one check on one executive's power this way would be that life tenure, and also the Senate has to also confirm these judges. Next slide. Presidential pardons. So this one is S tier for very good reason. While you can only pardon as a president, you can only pardon federal crimes. You can pardon pretty much anyone for any reason, and you can absolve them of any criminal conduct. Some frequent famous ones were President Biden's full pardon for his son and other high executives in his administration, and also President Trump pardoned many individuals involved in the January 6th Capitol attack. So it happens quite often. One other famous one would be the pardoning of President Nixon by President Ford. And one special exception to these pardons is that the action that the pardon is pardoning, okay, lots of using the word pardon there, have to already happen. So I can't actually give a preemptive pardon for a future crime. It has to already happen. So in the case of Hunter Biden and Dr. Fauci, which have been in current events, it was for actions that elapsed during a certain time period in the past. So you can't look to the future and say, okay, Ernest, I'm going to give you a full pardon for whatever crime you may commit tomorrow. Yeah, that can't happen. But because of the frequency of which it is used and the unilateral power that it has to absolve crimes, then I put it in S tier. All right, so checks by the legislative on the other branches. So things we covered already, you can just kind of click through them. We covered overriding vetoes. We covered confirming executive. Okay, I guess we go back to WAR. And we also covered ratifying treaties. So these are some things that we talked about earlier. Um, and okay, here's a new one. WAR. Only Congress can declare war. And that's a good check because, while the executive, the president, is the commander in chief, he controls the army. Um, Ultimately, Congress can only declare war and, actually start hostilities. And this last happened in World War II with, I think, Congress declaring war on Romania, which was an ally of the Axis at the time. And it only requires a simple majority. Usually this happens before, war is declared. The president writes a letter to Congress, or in the case of, I think it was President Roosevelt in 1941, he actually went down to Congress and announced it. Um, so, yeah, this really is infrequent. Congress has only declared war 11 times in American history. And since World War II, we've engaged in countless other engagements, armed engagements with other nations. So how can we do that without declaring war? Well, instead of declaring war, the Congress has decided to give the president like lots of power to send their troops, the U.S. troops, to other nations without declaring war. And this happened in Vietnam, this happened in the Middle East, and this is happening in Iran right now. So, because how it's like sort of used infrequently since World War II, I would say that this check is in B tier. All right, next one. All right, so the power of the purse. Congress is the one who has the power of controlling money. And this is highly relevant because, if you recall the government shutdown we had last year, um, the federal government could not run, their websites couldn't even load because they lacked the funds to do so. And so every year you'll see, the annual budget proposals sort of being talked about. And the power of the purse uh, sort of covers all action, like, sorry, it funds all like sort of areas of the federal government, and only Congress can determine how much money each branch gets. And I put this in S tier because it's really important and really powerful to be able to to determine the funds for the rest of the branches. And so you can kind of imagine it as a check on the other branches of government because um, say Congress doesn't want something to exist, they can just fund it less. Right? All right, so impeachment. This is both orange and green because the Congress can both impeach members of the executive branch and it can also impeach members of the judicial branch. So how does impeachment work? A congressperson has to introduce articles of impeachment. Note that this is not actual impeachment, it's just introducing articles, and anyone can really introduce articles. Um, if these articles of impeachment are approved, then the Senate holds the trial. No executive has ever been, like, no president, sorry, has ever been impeached and actually convicted of that impeachment and removed from office. I think President Johnson in the 1860s almost got impeached. He only one vote saved him from getting removed from office and going down in history as the one president that got impeached for removing, I think, a cabinet official. Note that these charges are not criminal because Congress can't pass a law that determines criminality, right? They can also can't impeach someone and also put them in jail. Usually, the consequences of being convicted of after being impeached is you'll be removed from office. And impeachment has actually been successful in removing some executive officials, I'm pretty sure, but they've never been really used to actually remove the president. Rather, impeachment's used as a sort of form for giving clarity or giving clarity to the citizens and also to, I guess, for Congress people to fight for their constituents because constituents may call for the president's impeachment, and the congressperson will be like, yeah, let's impeach the president. And it'll result in some, I guess, transparency within the executive branch. Right, next one.
And I'll just add that only one U.S. Supreme Court justice in history has been impeached, Justice Samuel Chase. However, the Senate had acquitted him, so he remained in office. So no Supreme Court justice has ever been convicted. And I'll just note it's really important when you're talking about this in both your testimony and your Q&A to be super clear when you're talking about impeachment versus conviction, because a lot of people use the term impeachment by accident to describe conviction. So just being really precise with your words is something to keep in mind as you're going forward in this program.
Yes, thank you, Serena. Those are very important to get your terms right. The next check by the legislative on the judiciary is being able to create lower federal courts. So we talked earlier about the three different federal courts. We got district courts, appeals courts, and the Supreme Court. Obviously, the Constitution creates the Supreme Court, but Congress can create district courts and appeals courts. And throughout history, Congress has expanded the number of district courts and appeals courts in our nation. Um, we have many circuit courts, which are appeals courts, but it used to be that we had less circuit courts, and Congress had to create laws to create more. Recall that just something to remember is that the president can appoint these judges in the lower federal courts, so I guess it's balanced out. And because the ability of creating lower federal courts is important, but because the president can ultimately appoint these judges, I put it in B tier. All right, next one, please. All right, so on overriding court decisions, Congress can pass laws to go around the judiciary. Say the judiciary, you know, sorry, say Supreme Court, here's a case, and they say, Congress, we don't like this law that you passed. Congress can create another law. They can just do that because that's their power. And so that's a check on the judiciary. Some famous occasions include passing the Religious Freedom Restoration Act, both in 1993 and 1997, which followed Supreme Court decisions that sort of lowered religious freedom. The Civil Rights Act of 1991, Congress wanted to, or yeah, I think it was the Civil Rights Act of 1991. Congress wanted to go around the Supreme Court again. So yes, it's a really important power. I put it in S tier because of its ability to sort of triumph judicial review. All right, next one, please.
I will clarify, though, that the legislature does not have the power to override Supreme Court decisions interpreting the Constitution, or certain protections. But what the legislative branch can do is, if the Supreme Court had interpreted a legislative provision and Congress disagreed with that interpretation, it could pass a new law that clarified and expressly rebuked the Supreme Court's interpretation of its own law. It can also create more protections that the Constitution does not guarantee. So, for instance, in the Religious Freedom Restoration Act example here, the Supreme Court had previously, in a case, determined that the First Amendment did not protect the right of religious entities to use peyote for this idea because it was a generally neutral application regulating all drug use and it wasn't targeting a particular religion. And so that Supreme Court case determined that the First Amendment didn't protect those situations. Congress didn't like that, and so they passed a statute that was meant to restore protections where it's similar to the First Amendment, but now it's giving more protection by saying if it disproportionately impacts a religious entity, you get protected under the statute. So it's not saying you interpreted the First Amendment wrong, Supreme Court, but instead it's saying we're creating this new protection under the statute because the Supreme Court doesn't think that the First Amendment currently protects that otherwise. It is an important distinction because the Supreme Court still has the right to say what the law is and to say what the Constitution means. And the Congress cannot undo that particular thing.
Yes, but they can certainly go around it. And you can also pass an amendment, I guess, because famously the 14th Amendment was passed. I guess you could view it as in response to the 1857 Dred Scott decision, but the 14th Congress can definitely also pass an amendment, which is a much stronger version of overriding court decisions. Right, next one. Right, so we're going on to judicial checks. These are really broad but really important, and I put them both in S tier because number one, the court, any court, is generally seen as more impartial than both the executive and the legislative branches. So there's a sort of idea that the judicial branch is better handled to, declare acts of Congress and executive actions unconstitutional. If you are following current events, the executive something that the Supreme Court did to the executive branch was in Trump v. Slaughter, um, where they found that President Trump's firing of his officials was unconstitutional. This also famously happened in U.S. v. Nixon, in another closely held case. Sorry, I didn't say closely held. Another case that sort of resembles um, okay, I'm just saying words now. Some checks on the on the legislative could be, recently in 2013 in Shelby County v. Holder, we struck down, the Supreme Court struck down sections of the Voting Rights Act of 19, I think it was 65. I'm probably getting the year wrong. Um, and I would say that these sort of declaring acts of different branches unconstitutional to be very relevant to many units, and you'll be talking about actions of the Supreme Court a lot. Even if you're Unit 4 and you're talking about something that Congress is doing, it's good to keep the Supreme Court in the back of your mind because they can come knocking at any moment, and they have heard cases on practically any aspect of the Constitution. So it's good to keep track of what they're doing in the present day to be able to speak to them and what they're really saying in those opinions. So that's the end of this tier list. Thank you all for paying good attention. Thank you.
Great. Thank you, Ernest. So now we're going to head into a 10-minute break. So it's 11:08 right now. I'll see you all back in at 11:18 to continue on. Thanks.
All right, everyone, if you're done with your water break or bathroom break, we're going to go ahead and get started with incorporation. Can everyone see my screen? I'll take that as a yes. All right, so the basics of the incorporation doctrine are that it applies the Bill of Rights to the states through the Due Process Clause of the 14th Amendment. We're going to break down what all of that means. We're going to walk through a few examples, and then we're going to talk about what incorporation is not at the very end. But before we do that, I want to ask you guys, because you're at this point in the summer where you've done a lot of your summer homework, you've learned a lot about the Constitution. So what do you know already about incorporation? What do you think it is? So if you're able to chime in the chat, or if you want to raise your hand and chime in, that would be great. All right, I'm seeing a couple items in the chat. Make the states comply with parts of the Constitution, especially the Due Process and Equal Protection Clause. That's definitely part of it. I think that first half of making the states comply with the Constitution is definitely accurate. When SCOTUS makes national individual rights, state-level individual rights, yep, absolutely. Exclusive to the first 10 amendments. It's true. It doesn't include all of the first 10 amendments. So we'll talk about that as well, but that is correct. Anything else? All right, I think that's a good start. So you're right that the basics of incorporation is taking some of those national level rights that we have in those first 10 amendments, the Bill of Rights, and applying those to the states. At first, those were only national rights. The Bill of Rights was passed in 1787. All 10 of those amendments were only intended to apply to the national government. That was done for a number of reasons, but mostly for a federalism reason. There was no reason for an overzealous federal government to tell the states what they had to do. The federal government at this point was fearing the abuses of Britain, everything that they had seen already happening under colonial rule. And their goal, as you learned in Unit 2, was to make a federal government that wasn't too weak, like the Articles of Confederation, but also wasn't too strong. And so they found this balance with the Bill of Rights where it would only apply to the national government, and then states could have their own constitutions, their own bills of rights as they wanted. So during those first 100 or so years of the Constitution, the Bill of Rights applied to the national government as needed, and state constitutions filled in the rest. You might be familiar with documents like the Virginia Bill of Rights, Virginia Declaration of Rights, or similar documents that protected rights at the state level. But I said only for the first 100 years that occurred. And that's because about 80 or 90 years into our nation's history, there was a big event that happened, the Civil War, and the federal government could no longer trust the state governments to uphold rights. So in following the Civil War, the national government no longer had this lofty idea that they could trust the state governments to protect all of rights. It had been proven during the Civil War and also before that state governments simply maybe could not be left to their own devices, that they needed a little bit more hand-holding. And so following the Civil War in 1868, the 14th Amendment was ratified to bridge those fundamental protections to not only apply to the federal government, but also to the state government. And Section 1 of the 14th Amendment served as this constitutional written bridge. It said that no state shall enforce any law which shall abridge the privileges or immunities of citizens, nor shall any state deprive any person of life, liberty, or property without due process of law. So this is obviously very vague wording, right? There's a big question here of what are the privileges and immunities of citizens and what life, liberty, and property without due process of law are. They're very vague concepts. It would be nice if the Constitution defined those better, but it's very difficult to do that during the drafting process. And so it was up to the Supreme Court to slowly define these. So the Supreme Court started with this first half of Section 1. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens. That's a vague term, and the Supreme Court tried to define it, potentially to include the Bill of Rights. That happened in cases that we call the slaughterhouse cases in the 1870s, which used that privileges and immunities clause and sort of tried to define it a little bit more. These cases are important for a number of reasons. Any unit that deals with citizenship will read them and talk about them extensively. But as far as incorporation goes, the slaughterhouse cases were important because they basically denied the possibility of including the Bill of Rights in that clause. The cases stated that the privileges and immunities of citizenship did not necessarily include the Bill of Rights, and so incorporation had to be done by a different method. That's when, going back to this quote, the Supreme Court looked again at the second clause, life, liberty, or property, and incorporation really went from there. We looked at what articles of the Bill of Rights, what amendments of the Bill of Rights could be included in this description of life, liberty, or property, and how could we make sure that no state could deprive those? So there were sort of two options for how this could happen. And the Supreme Court had a big debate for themselves about how to start including the Bill of Rights into that life, liberty, and property description. And there were two options that were debated. First was the process of selective incorporation, where rights would be incorporated one at a time on a case-by-case basis. Basically, where once a case or controversy came up, the Supreme Court could decide whether that specific amendment in the Bill of Rights would apply to that life, liberty, and property description. Alternatively, the Supreme Court could do it all at once through a process of total incorporation, where rights would be incorporated all at once during a single case or decision. If they had gone down this road, there would have been one case we would be talking about that would have incorporated the entire Bill of Rights. And they could have gone down that road. So I want to ask, before I talk about the reality of it, and you might be familiar with the reality of it, let's talk about the pros and cons. So first, why might we go down that road of selective incorporation, putting rights into that description on a case-by-case basis? You can chime in by raising your hand or in the chat. All right. Sahil, total incorporation is a lot of extra burden to put on states. Absolutely. Makes the transition easier instead of states losing a bunch of powers all at once. Yeah, absolutely. So a lot of federalism concerns about the relationship between the federal and state government. Selective incorporation can specify how rights should be incorporated. Yeah, adding a little bit more detail or clarifying rights a little bit more. Any other concerns here? Maintains federalism. Yeah, absolutely. Yeah, those were a lot of items that the Supreme Court talked about while they were making this decision. And then I also want to ask, are there any pros of total incorporation? Why might we just get this all over with at once rather than waiting and doing it case by case? Make sure all rights apply equally across the entire country. Yeah, that's part of it. Legal clarity. Yep. Sometimes with a Supreme Court decision, it might be unclear what rights are incorporated versus not incorporated, especially if it's only targeting one part of amendment and not others. Yeah, so I think you guys hit on a lot of the major points. Selective incorporation works a lot better with the structure of our government, maintaining that relationship between state and federal government. Total incorporation is kind of just easier. It's simpler, it's more clear. But in the end, the Supreme Court chose to forgive the clarity and go with selective incorporation and do this case by case. And there were three main reasons for this. You guys got federalism. It protects states from an overzealous federal government by allowing these decisions sort of happen one by one. The federal government's not going to basically kill those state rights all at once. But there are two more that are also important here. So first is judicial restraint, which is the Supreme Court always seeks to avoid any sweeping or major decisions. This is true for incorporation cases. This is true for every case that they decide. The Supreme Court looks to decide in the least, like basically the lowest profile way possible. So if a case comes up, they're going to make the decision that solves the case at hand and nothing more. So it would have been difficult to hold that principle of judicial restraint if the Supreme Court had decided for the entire Bill of Rights all at once. It's very inconsistent with the principle of judicial restraint. And then likewise, the Supreme Court is limited from making advisory decisions. Article 3, Section 2 of the Constitution limits the Supreme Court to deciding cases and controversies that come before them. And so given this clause, the Supreme Court, as you know, decides one case at a time. A case might come up where someone's speech is infringed on, their property rights are infringed on. And at that point, the Supreme Court could decide, based on that case or controversy, whether that piece of the Bill of Rights should be incorporated. But if they had issued a decision all at once, incorporating the entire Bill of Rights, it might have violated that cases and controversies principle. So in the end, they chose selective incorporation, and over the course of the last 150 years, have slowly been working to incorporate all of those cases. So I'm not going to spend too much time on the cases incorporated. There's a list of these in the case folder, but it's going to be a helpful resource throughout the year. But I just want to give you a brief overview of sort of the timeline of how these were incorporated and what rights are and are not incorporated. So first, the First Amendment was really the first rights that were incorporated under this due process clause of the 14th Amendment. And this happened in a big wave from the 1920s to the 1940s. Speech and press came first. Gitlow v. New York, someone mentioned this in the chat earlier, was the first case to explicitly incorporate freedom of speech and defined selective incorporation. So Gitlow was this situation. It only implicated speech. None of the other rights, press, assembly, petition, religion, none of those other rights in the First Amendment were implicated because the Supreme Court chose this path of judicial restraint. But Gitlow was a landmark case and was one that gets cited a ton when it comes to incorporation because it was the first one to incorporate any right to the states. And so Gitlow set the model for all of the cases that came after it. For the remaining First Amendment cases, Stromberg v. California incorporated symbolic speech, basically saying that states could not only not restrict speech, but they could also not restrict symbols, something that you were wearing, a flag that was raised, an armband, anything like that. States were also held to that standard. And then likewise, Neer v. Minnesota, 1931, protected freedom of the press from prior restraint, which is basically the process by which a state might try to restrict a publication before it is issued. That happened in Neer v. Minnesota. A state tried to restrict a publication, and the court said, no, you have to follow the First Amendment.
From there, assembly and petition were the next rights to be incorporated. DeJong v. Oregon, 1937, incorporated the right to peaceful assembly and prevented states from infringing on groups gathering to assemble either for protests, strikes, anything like that. Then right after that, Hague v. CIO, 1939, incorporated the right to petition. From there, you've incorporated 4 out of 5 parts of the First Amendment. You might as well work on the others. So while they were at it, Supreme Court incorporated religious freedom via Cantwell v. Connecticut and Everson v. Board of Education, 1940 and 1947. Cantwell incorporated the Free Exercise Clause, which states that, well, first, the national government could not interfere with the free exercise of religion, now saying that states could not interfere with that either. And then Everson v. Board of Education has incorporated the Establishment Clause, stating that states could not establish, I guess not a national religion, but a state religion, or do anything with additional entanglement. From there, now that we were through the First Amendment, the Supreme Court moved on to other rights as they came out via these cases and controversies. The Fourth Amendment, protecting against unreasonable searches and seizures, was incorporated first in Wolf v. Colorado in 1949, which protected the basics of unreasonable searches and seizures. And then Mapp v. Ohio extended that by incorporating the exclusionary rule, banning illegally seized evidence from state criminal trials. The exclusionary rule is extraordinarily important, comes up all throughout Unit 5. It's basically a way of enforcing the Fourth Amendment, because even if an unreasonable search and seizure is unlawful, if that evidence can still be used in trial, the Fourth Amendment's really not doing its job. So Mapp v. Ohio incorporated that right as well, basically protecting people even further from unreasonable searches and seizures. From there, a few Fifth Amendment rights came up, specifically due process. In Malloy v. Hogan, 1964, the privilege against self-incrimination, which you might often hear as taking the fifth during a criminal proceeding, that was incorporated, allowing people to protect themselves from incriminating themselves during a state trial, not just a federal trial. And then likewise, in Benton v. Maryland, 1969, the protection against double jeopardy, or being tried twice, was incorporated. This one's important because it also addressed issues of stare decisis, because that protection against double jeopardy had been previously tried before the Supreme Court. And the Supreme Court had previously said the double jeopardy provision did not apply to those states. So Benton v. Maryland overruled that and created this new standard that states would have to be held to the double jeopardy clause as well. This will come up often. We'll talk about it a little bit later. A lot of times these incorporation cases are actually overruling prior precedent that say that these rights don't apply to the states because the nature of incorporation changed so much over time. I apologize if there's background noise. I think there's someone sawing in the backyard behind me. So from there, the Sixth Amendment rights to generally a fair trial were incorporated throughout, starting in the 40s and continuing especially through the 60s and 70s. This was a really important period during incorporation. It was under the Warren Court, which is a famously liberal court in the 60s and 70s, tried a lot of famous cases that pushed the court in a more liberal direction. You might have a couple others coming to mind, but in the realm of incorporation, the Warren Court really pushed forward this incorporating the Sixth Amendment. So first, with right to counsel in Gideon v. Wainwright, 1963, states had to provide an attorney in felony cases, basically saying that if you can't afford an attorney, one must be provided for you. It's a super critical provision, especially for people with lower income or with lesser resources, especially given that that case happened during the Civil Rights era, right in 1963. That was an extraordinarily critical case. Then likewise, Argersinger v. Hamlin, 1972, this provision where states must provide the attorney was extended to misdemeanors involving jail time. So not just felony cases, but also certain misdemeanor cases, the state had to provide an attorney. Additionally, during this era, the right to a jury and a public trial were incorporated. In Ray Oliver, 1948, the right to a public trial was incorporated. Then likewise, the right to an impartial jury and a jury trial in criminal cases were incorporated in Parker v. Gladden, 1966, and Duncan v. Louisiana. And then finally, Certain court procedures were also incorporating during this period. Cole v. Arkansas in 1948 incorporated the clause for a notice of accusation, basically saying that states had to provide you a notice if you were accused of a crime. Klopfer v. North Carolina in 1967 incorporated the right to a speedy trial, basically ensuring that states had to try you and give you a decision in a relatively short amount of time and not extend trials for unreasonable amounts of time. And then Pointer v. I'm trying to remember what the full names of these cases are. But Pointer, 1965, and Washington, 1967, incorporated the rights to confronting witness in certain compulsory processes. You can find more information on these in that handout that's in the Drive folder. And then lastly, there have been a couple more recent provisions. Most of the incorporation slowed down after the 60s and 70s, where most rights were incorporated. But since then, there have been a few remaining cases that have come up. So with the Second Amendment, there's a famous case from 2008, DC v. Heller, that sort of modified and expanded the Second Amendment. And then from there, in 2010, McDonald v. Chicago applied that extended interpretation to the states as well. So basically adding on to DC v. Heller. And this case incorporated the individual right to keep and bear arms for self-defense in the home against state and local gun regulations. So this extended interpretation basically codified that each person is allowed to bear arms in their home and basically for self-protection. Prior to that, the Second Amendment had more been interpreted as a right to bear arms in the way that it's originally written, which is essentially for militia purposes. Very different than how we understand it now. So McDonald v. Chicago was more codifying that right to bear arms and ensuring that states didn't infringe on it. And then the Eighth Amendment against cruel and unusual punishment was incorporated separately in 1962 and 2019. Robinson v. California, 1962, incorporated freedom from cruel and unusual punishment. So excessive jail time, any really cruel punishments like certain death penalty applications, or stuff like the electric chair, which has been frequently overruled with the Eighth Amendment, basically preventing states from issuing cruel and unusual punishments. And then in Timms v. Indiana, 2019, that was extended to excessive fines. This is a fun case to dive into. Basically, the state tried to impound a guy's Land Rover for a pretty minor misdemeanor. And that $40,000 car was considered an excessive fine in this case. But that's really the most recent interpretation that we've gotten of the incorporation doctrine. So since then, there hasn't been much happening since that 1960s era. These McDonald and Timms are really the two most recent cases. And there's a valid question there of why has incorporation slowed down? And that's because we've really gotten to the point where most rights have been incorporated. The only remaining ones are rights that are either not necessary for states or simply don't come up very often. So you guys followed along as we walked through the First, Second, Fourth Amendment, Fifth, Sixth, Eighth. I'm curious, hearing all of that, what rights have you been thinking about that aren't incorporated? There's three that I'm looking for, so I'm curious if you guys can name them. Freedom from housing soldiers. Yep. Third Amendment rights. Gerard and Advaith, you both got that. There's two more that I'm looking for. If you need to, pull out a pocket constitution or pull it up on your computer. You can take a look at the Bill of Rights. I want you guys to get one more before I move on. Seventh Amendment. That's the other big one that stands out. There's one more sort of more minor provision that I'll talk about, but you guys got the two major ones, which are the Third Amendment and the Seventh Amendment. So between Amendments 1, 2, 3, 4, 5, 6, 7, and 8, there are only three provisions that remain unincorporated. There's a couple very minor wording changes that also haven't quite been incorporated, but these are the main ones. So the Third Amendment which, as you know, protects from quartering of troops in private homes during peacetime, hasn't been incorporated simply because it hasn't been tested. Like I mentioned, Article 3, Section 2 forces the Supreme Court to only decide cases and controversies that come before them. They can't issue an advisory opinion. And so, given that no federal or state government has quartered troops in private homes during peacetime, the Third Amendment has simply not been tested. The general understanding of this one is that if it ever came up, if there were ever a case that challenged the Third Amendment, it would be incorporated immediately. It's such an important right, so critical to our nation's founding, that it would be incorporated if it ever came up.
I just
These
want
other
to
two,
jump in
yeah,
here really quick. There have been some very creative attorneys who have tried to use the Third Amendment in order to challenge the right of police officers to use private property to investigate or look in on a neighboring house. And so it has been tried to get into the dialogue, but no judge has found that the Third Amendment applied in those situations. And so it hasn't reached this issue. But there has been some creativity around that. So it's always kind of a fun way to think about things, especially when you're talking about police officers or state officials using private property to carry out their functions.
yep. Frequently those end up Sabrina, correct me if I'm wrong, but frequently those end up falling under Fourth Amendment protections. Am I right?
That's right as well, yes.
All right. And then the other two on here are the Fifth Amendment, right to a grand jury indictment and felony criminal prosecution. The way our trial system functions right now is an indictment is usually done based on the facts or information. Right to grand juries are used very frequently in federal criminal trials, but it's simply unfeasible to happen at the state level. There are millions of these trials that happen every year, and having a grand jury for each one would basically be unfeasible and slow down the process. And so the Supreme Court is very practical in many of these cases and understands that even if it might be good, there might be additional protections that a grand jury could provide over judge indictments, but it's simply not practicable in these cases. And then likewise with the Seventh Amendment, right to a jury trial in civil court cases, there are millions of civil court cases that happen every year, and having an additional right to a jury trial would be an excessive burden on the judicial system, such that these two have come up, they've been talked about, but have never been incorporated to the states and remain only to the federal government. Lastly, so those are the three that are unincorporated, but there's also some nuances here that I want to talk about very briefly before we wrap up. So the process of incorporation, as I've discussed it, is basically, it's very simple. It's applying a right that applies at the federal government to the state government. However, the way that has been done has changed a little bit since 1925 in Gitlow v. New York, that first time we tried it. So previously, in the mid-1900s, as a lot of these rights were first being incorporated, there was what we called a dual track system, where rights might apply differently at the state versus the federal level. So oftentimes, the right would be less strong at the state level, whereas something, say the right to a jury, might apply very strictly. There might be a lot of protections that are afforded at the federal level. It might not be applied as strongly or give as many protections at the state level. So that was interpreted, a lot of rights were interpreted that way during the mid-1900s, such that there was sort of this two-level system where rights were stronger at the federal level and less strong at the state level, and state constitutions sort of made up that difference. But in more recent years, really since the 1960s, we've followed a more what we call a single-track incorporation, where rights applied to the same extent at the state and federal level. Basically meaning that if a protection applies at the federal level, it is also going to apply at the state level. So one famous example, and actually a recent example of where this happened, was with the right to unanimous jury. So it's been very established for a long time that jury trials are required both at the federal and state levels. That was one of our incorporation cases that we talked about earlier also. But under the dual track method of incorporation, a unanimous jury was required only in federal trials, not state trials. So basically, state criminal trials could convict someone, say, with a 9-3 or 10-2 judgment. This was a pretty critical decision in Apodaca v. Oregon, 1968, that actually was basically made the protection significantly weaker. You can imagine that if someone is being convicted with a 10-2 or 9-3 verdict, that there's actually a chance that they might not be guilty, that there's only like a preponderance of evidence, but not necessarily a clear conviction. And so this was something that was later corrected in Ramos v. Louisiana, 2020, stating that a unanimous jury was required in both federal and state trials. But this is an example of that dual track versus single track incorporation. In Apodaca, the right to a unanimous jury applied at a weaker level at the state level versus the federal level, basically allowing state governments to infringe on more rights than the federal government would be allowed to. And so Ramos was a pretty major correction and is a really interesting case to dive into. There's a racial aspect to it. There's a stare decisis aspect to it. It's a really interesting one to read through for a Unit 5, Unit 3, or even a Unit 2 who wants to dive into federalism. So in the end, I think that is all I have. Those resources that I mentioned earlier, that list of cases that are incorporated, will be a very helpful guide, especially for Unit 5 during the semester. But I encourage all of you to think about incorporation. There's a federalist aspect to it. There's a racial and due process aspect to it that Unit 3s will have to deal with. There's also a very philosophical aspect to it that might interest a Unit 1. So no matter what unit you end up in, no matter what you end up diving more into, I encourage you to continue thinking about incorporation and incorporate it into your testimonies and into your Q&A. In the meantime, I know this is a complicated topic, so if you have any questions, I'd be happy to talk about them or answer them now. You can drop something in the chat or raise your hand if there is anything.
All right, thanks, Patrick. I'm not seeing any questions, but y'all are welcome to continue asking us throughout the year. We are going to switch gears and go into our final section of this summer session, which is you preparing for mock hearings. You all are going to prepare a 4-minute testimony to answer the question I'm putting in the chat, which is, what is the most important right in the Bill of Rights, and what is the least important right in the Bill of Rights? So we are going to put you into breakout rooms. It'll be groups of primarily 5 of you, plus a case member who will sort of supervise and help answer questions. But the idea is that you all will get a Google Doc going. You will start collaborating, doing research, adding evidence. And I want to hear a clear answer to both questions in your testimony. And I want it supported with constitutional cites, evidence, reasoning, and application. A lot of the things that we talked about in the rubric. So we're going to expect all those elements. You're going to have 50 minutes to put that together. At 12:40, you're going to present it in your room to the case volunteer, who will then give you feedback on your presentation. Now, we know this is your first time doing it. We also know that you only have 50 minutes to do this. So we don't expect it to be perfect, but the idea is that we want you to try to incorporate all of those elements in the time we have. And your case volunteer will be in the room answering questions you have if you want guidance. One thing I want to make clear, I'm asking what the most important right and the least important right is, not the least or most important amendment. So the First Amendment is not an answer to the question. It has to be one of the rights within the First Amendment. Speech, petition, that sort of thing. So make sure you are picking one right for each of these answers to discuss and supporting it with evidence. At 12:50, we're going to all come back and do a final vote after you share some of the thoughts that you all provided in your research and evidence from the breakout rooms. So I'm going to open all the rooms now. If you have trouble getting in for whatever reason, hang tight and I can make sure to get you to the right place. Evelyn, are you able to get into the room? Evelyn?
Evelyn? How can I join one of the breakout rooms? Nice.
All right, I see we've got 4 groups in here. Nathan, do you know what breakout rooms are still running?
Oh, I don't think I do. Let me pull it up. It looks like room 1 is still not in. Uh,
Room 6 looks like they're joining back here, and then room
and
7,
room 7.
Sabrina's room. Oh,
Dang.
all breakout rooms will close. We're coming back.
Sweet.
All right, welcome back to the main room, everyone. Good to see everyone. I think Sabrina should be joining us in just a minute. And then we've got a couple more people still in room, so we'll wait that last 30 seconds.
Oh, you're no longer outside.
No, I moved back to my room. It got a little too sunny out in Berkeley. Enjoying the last little bits of the summer before we go back to 5 p.m. sunsets.
Oh, yeah. 5 p.m. sunsets. I
All
guess
right.
oh, sorry.
Sorry, I just want to dive in. Oh, we're recording again. Great. Okay, thanks everyone for your participation in that. I know it's really hard to throw together a testimony so quickly, but now you know you can do it, which is the most important thing. And we're really excited to work with you as you do this program for real going forward, and we can help make sure your testimony is strong, give you feedback, and help prepare you for the program going forward. I know we're running a little bit behind, so instead of doing the normal calling people to say what your justification was in the chat, instead I want everyone to put what they had in their room as the most important right and what was the least important right in the chat. I'm going to develop a poll as I read your answers to make sure I'm capturing everyone, and then we will do a final vote. So get started in the chat. Maybe I can have some of my volunteers read them out loud to me so I can go faster.
Sabrina, is not going to surprise you. There's not a lot of variety, but for most important, we've got free speech, free petition, impartial jury.
More impartial jury. I don't know.
We got the right against search and seizure.
Ooh, good one.
And then I guess you need the lease now. The
Yeah, just
least
give me
everyone says
everything. I'm gonna make it all just the same.
everyone says the least is quartering, like the third.
You guys want to have troops in your homes? Just kidding. Any other things we missed? Does anyone want to put any edge cases, ones where their group might have almost selected it but didn't?
I think our group almost chose due process as the most important, right?
Okay, love it.
Yep.
We also had a quick shout for cruel and unusual punishment is least important.
Least important. Oh boy.
Yeah.
My group also initially brought up as least important the Second Amendment right to bear
Mhm.
arms. So I will add that for fun.
We had grand jury and civil cases brought up.
Okay.
I think there was also a quick moment of the Ninth Amendment and like enumeration rights as well. So basically, I think we got the entire Bill of Rights.
Great. Okay. I am going to finalize the poll momentarily. See, we do all of this live just for you all.
And in Technicolor.
And in Technicolor, exactly. Okay. Oh, these Zoom YouTube is just me like staring and working on goals. Okay, I have saved it and I am publishing it now. So for those tuning in at home, the options are for most all of the rights at issue are free speech, quartering troops, petition, impartial jury, search and seizure, quartering of troops, I have twice, sorry, due process, cruel and unusual punishment, right to bear arms, civil grand jury, Ninth Amendment enumeration. Almost everyone has voted. I'm waiting for 2 people to vote. 1 person to vote. All right, and the results are in. The most important right in the Bill of Rights for 2026, case summer session 3, is free speech with 60% of the vote. In second place is a right to an impartial jury at 11% of the vote. And then due process and the right to petition the government is tied for third at 9%. Excellent. And the least important right in the Bill of Rights is the quartering of troops in the Third Amendment, which got a healthy 77% of the vote.
Oh, it's more they had split among the two options. It's 88%.
You're right. Thank you. Yes. 88%. Excellent. We did have some votes for free speech as the least important right, which is very controversial. Love that. Also got civil grand jury in there and cruel and unusual punishment as part of the vote. All right. Thank you all for participating. We really appreciate your time and energy for this last summer session. I know there was a bit of a typo on our agenda today that said we started at 11 a.m. when we actually started at 10 a.m. So I know a few of you missed the first hour of the presentation. That was my fault. I'm sorry. I will let your teachers know. But the whole summer session is going to go up on our YouTube channel, so you'll be able to catch up there, and I will try and get that uploaded as soon as possible. The other 2 summer sessions have been uploaded as well, summer session 1 and summer session 2. So feel free to go back if you missed it or to rewatch if you just want to relive the magic. Thanks, and hope you all have a great weekend.